Constitutional Court at paragraph 45 is that even under the constitutional dispensation, there is no need to develop a new test. The test remains that, but seen in the light of the impact of the Constitution, and that's why you look at separation of powers and so on. So just to clear that even when looking at whether the consequential relief that our learned friends contend for, Mr. Mpofu, under following upon a declarator, if that is to take the form of an interdictory relief or a postponement, that's an interdict because he's suspending the proceedings, he must still satisfy the requirements and heightened by the requirements of outer, because this is to restrain the exercise of statutory and constitutional powers and to restrain the fulfillment of those functions by the JSC.
Well, the separation of powers harm, if it becomes relevant, is the same as what you say tips the balance of convenience in the JSC's favour, isn't it? I mean, all of the reasons why in outer the Constitutional Court says that there's separation of powers harm are the reasons given in those two affidavits by Ms. Pillay and Mr. Toby as to why the JSC should be allowed to get on with it.
Yes.
The separation of powers harm is about allowing the state to get on with its statutorily mandated functions.
Exactly.
And those affidavits, well, this is what's going to happen if we can't.
Yes, quite.
Those inquiries sort of fall into one another, don't they?
Yes.
If you get to an interim interdict test.
Yes.
Yeah.
All I was saying, my lord, is not as if the consequential relief that he asks, that MK asks under section 172B, if it takes the form of an interim relief, is somehow assessed outside of the Sutlo-Helo test. No, it is in that test.
Thank you.
To turn to the reasons, my lord, I'm going to refer, my lord, to our heads, and I'll follow a lot of the structure of the heads. At page, paragraph 39.1, we reproduce the reasons. The first reason is that the JSC was bound by the judgment and order of the Western Cape High Court. And that is addressed in full in the heads from paragraph 84. Now, there are important constitutional provisions which require the JSC to not only obey the orders of the High Court, but to assist to ensure that those orders are taken into effect. And that is section 1C of the constitutional rule of law provision, the supremacy of the Constitution, and all of both of them bolstered by section 165.5 of the Constitution, which says orders of courts are binding. They are binding until they are set aside or suspended by appropriate orders of those courts. And initially, the suggestion in the founding affidavit for the MK party was that the JSC is irrational because it could not be bound by a judgment of which it wasn't a party. And you will see that my learned friend hasn't persisted in that was clearly wrong, because the judgment of the Western Cape High Court makes clear that the JSC was a respondent, and it abided the decision of the court, and that means it's bound by that decision. The second point they make is that somehow the application for leave to appeal suspended that order. You will see in the letter to the JSC, and this is very important. In the letter to the JSC, and perhaps I can just point the court to that letter.
Yes, it's an annexure to the
they went certain themselves on the implications of the application for leave to appeal. I flagged it. But
letters at 02-120.
Yes, but the only point I make is that they said it's unclear, it may be suspended, perhaps it's not suspended. They were not categoric that the application for leave to appeal has suspended the order. Because if that was the case, their demand would have been a different one to the JSC. It wouldn't have been postpone the judicial service, postpone the proceedings. It would have been confirm that my client will be allowed to attend, because the operation of the High Court order has automatically been suspended by the application for leave to appeal. That's not what they asked, which shows precisely that in fact, the letter is very specific that judgment remains operative. Yes. In fact, they make it clear in that letter that the order and judgment of the High Court remains operative. And then they hedge their bets by saying there might be some debate. There may be grey lines. I'll show you that by reference to an argument my learned friend Mr. Mpofu made to this court. He persuaded the court that an interim interdict is an interlocutory order. I mean, it doesn't automatically, a leave to appeal doesn't automatically suspend other than by a court order. You will see.
Well, your point is, if the application for leave to appeal did suspend, then there'd be no point in postponing either.
There wouldn't be.
Dr. Hlophe could just come.
Yes.
Yeah.
And then they would be coming to you to say the JSC refuses us to go, refuses Mr. Hlophe to attend, when in fact the order of that court has been suspended. Yes. You will see that it's paragraphs 10 and 11 of that letter, and Malot can have a look at it. Paragraph 10 says, this
I have it.
that is really what we are referring to. It says, for present purposes, we therefore accept, as we are legally bound to do, that the judgment, however erroneous, is legally effective until the appropriate proceedings may have been instituted and finalized in terms of section 17 and or 18 of the Superior Courts Act. That is common cause, they say. What is at issue for now is not the legal effectiveness or executability of the judgment, but its legal impact on the 7 October sitting. So, and then they have it may well be that there is some debate at paragraph 11. But they told the JSC, it's common cause that judgment and order remains effective. How they today complain that the JSC says it is bound by that order because that order remains effective, it's really a lawyer's argument. At the point when the client wrote on instructions and advice, it said it was common cause. But that's probably by the by. The real point is it a wrong conclusion or irrational conclusion for the JSC to hold that that judgment remains effective and is binding on the JSC? We submit not. And we deal with that from paragraph 88 of our heads. You will see that we first highlight the two sections that are the three sections of section 18 subsections, 18.1 and 18.2 and 18.3. And we refer to the judgment in Old Mutual and others with Moyo, in which my learned friend and I, Mr. Mpofu, were on opposite sides initially, and then I fell off subsequently. But what we had done, because my learned friend succeeded in obtaining an interim interdict, restraining for the interim pending an outcome of a Part B relief, the dismissal of a CEO of a company, Old Mutual. Old Mutual filed a notice of application for leave to appeal, and there had been ongoing disputes about whether he's allowed to return to the office in light of the order of the court or not. And Old Mutual sought to argue that the order had final effect, and therefore the leave to appeal automatically suspended the order. On the eloquence of my learned friend, the court found, and we quote from paragraphs 88, the interpretation that the applicants want to assign, and that's Old Mutual, to the reinstatement order is manifestly farcical. I'm at a complete loss why anyone would want to read a sentence that states that the first respondent is temporarily reinstated pending the finalization of Part B to be final. A plain reading of that sentence is clear. Even with the interdict relating to the prohibition of the appointment of another chief executive officer, it is apparent when reading it against the background of all the papers in the application that the intention is for it to apply until the finalization of Part B. An interpretation that is in stark contrast with the quoted passage from Ndumeni Municipality case Supra stands to be rejected as bereft of reason, and the orders that this court granted on 30 July 2019 cannot accommodate a construction that they are final and definitive. On a proper reading of the order of this court dated 30 July 2019, and having regard to what was held in Ndumeni Municipality case supra on how documents should be construed, the relief sought and granted was interim in nature. Despite it being interlocutory, it was in the interest of justice that the order should nonetheless be appealable. That was a separate question on appealability and the interest of justice. But the point is, it's interlocutory, and it doesn't automatically suspend the order of the court. And with respect that, the court took interlocutory
and not having final effect.
And not having final effect. And interim orders don't have final effect because the judgments that they render can be reconsidered and changed by the court hearing a final application for final relief. So the review court...
You've got to apply the Zwini test.
Yeah, the Zwini test.
I mean, it comes in and out of fashion, doesn't it? But for the purposes of this... For the purpose of this case, I think the finality of the, or non-finality, if I could put it like that, of the full court's order is to be determined by reference to that test.
Yes, quite.
So what your submission is that the first leg of that test is satisfied because the full court's order is open to interference at a later stage by the same court.
By the same court. It's interlocutory also in the sense that it's incidental to the main relief. It's relief pendentilite. The pending proceedings are the Part B proceedings. And that's why it's always linked to those proceedings. If you can't have an interim interdict in the A, it must be linked to pending proceedings. In that sense, it's interlocutory, and we refer to the judgment at paragraph 91 of South Cape Corporation. It doesn't have the effect of res judicata in the wide sense, because it doesn't finally determine the rights of Dr. Hlophe, for instance. It's not finally determinative of his rights. Those rights, on all accounts, will be determined under Part B or on appeal. So it is that order is clearly and unambiguously interlocutory. And the effect of the application for leave to appeal is not to suspend that order, and the JSC was correct in taking that decision. But I don't have to persuade my lord that the JSC was correct. No. All I have to show is that it was rational in taking the decision. Now, I don't know which judgments it read, but I assume it might have read. One of them might be Marlene Friend's success in Old Mutual. And that would be sufficient to render that reason rational. The second reason, my lord, in the reasons is that the judgment and order of the Western Cape High Court did not set aside Dr. Hlophe's designation as a member of the JSC. That much is common cause. That he remains a member. My learned friend, Mr. Galwana, emphasized that point. So he remains a member of the JSC. The only thing that has been interdicted in the interim is for him to attend JSC meetings. But just for the court's reference, we deal with that from paragraph 94 of our heads when the court looks at that point. But I'm not going to dwell on it.
Yeah.
The third reason, my lord, is that the October sitting and any decisions that flow from it will not be rendered unlawful, even if Dr. Hlophe is not able to attend. And first we make the point that that is a finding which the High Court in the Western Cape itself made. And it made those findings at paragraphs 56 and paragraph 68 of the judgment. And in fact, related to the different point which our learned friends make, and I'll come back to it, which is to suggest that the judgment of the High Court impugns the designation of the other five. That, with respect, is just wrong. And it's wrong for the clear reason that my learned friend, Mr. Mpofu, read out from a paragraph, but he didn't complete the reading, and that is paragraph 56 of the judgment. And my lord, always one understands the effect
56 of the 2013 case.
I beg my lordship's pardon? It's 02-66. What's your?
Oh, have you got it on
Okay, that's
Judicial Services
yeah,
Commission
mine is
versus
on
Cape Bar Council.
02-66 years.
Judicial Services Commission versus Cape Bar Council. Is that the decision?
No, I was looking at the High Court judgment in this case.
Oh.
It is. It's in the.
Oh, sorry.
It's attached to the founding papers.
Yes. No, sorry, I was looking at the wrong judgment.
Yes.
Carry on. Paragraph 54.
56.
56.
So, my learned friend read part of it to demonstrate that the court was mistaken by referring to quorum instead of composition. But if you had read further, what we want to do is to read further than that. So it says the respondent's submission that the JSC would not have a quorum in order to take valid decisions if Dr. Hlophe is interdicted from participating in that forum is incorrect. In acting the Premier's case, the court pointed out that the majority support for decisions required by Section 178(6) is the majority of members entitled to be present according to Section 178. In that case, the issue was whether the Premier's attendance was necessary. The court concluded that it was bearing in mind 1781K of the Constitution. In this case, the absence of Dr. Hlophe and on the JSC would not be significant.
Yes, Mr. Hlophe was quite emphatic on this point.
Yes, but he didn't read the last sentence, my lord.
Yeah.
There would still be 5 NA members represented on the JSC, constituting a majority of such members. I'm making a different point, that if the court impugned the designation of the 5 members, it wouldn't be making the statement at paragraph 56.
Oh, I see.
Yes. Yeah. It didn't impugn that because, my lord, the court's reasoning must be read to its logical conclusion. When the court says in the context of Dr. Hlophe, the National Assembly failed to exercise, to appreciate that it had a discretion and to exercise it. It's because in his case, if the discretion was exercised, they would have taken into account that he had been removed as a judge. And you will find that in the reasons. But you wouldn't reach that conclusion with the other 5 members. So it's not simply to read half bits of the judgment and say, but they're saying they're impugning the entire, the way in which the JSC exercised its discretion and did not stop at only Dr. Hlophe.
I mean, to be fair, Mr. Hlophe didn't really concentrate a great deal in his argument on that point.
Yes.
What he was saying was that for the same reasons as was found by the Supreme Court of Appeal in the Cape Bar Council and Premier of the Western Cape case,
yes,
non-attendance by Dr. Hlophe in this instance means that the JSC is improperly constituted.
Yes, I'm coming to that.
Yeah.
Yes,
that just seems to be the main point.
That was the main point.
I understand what you're getting at,
yes.
but insofar as the rationality of the decision of your client is concerned, it seems to me that that's the first of 2 critical points you have to meet.
Yes. I mentioned that point because the reason they say the JSC's decision is irrational is first for the reason I've already addressed about the binding effect of the judgment, but they also say the composition would be unconstitutional. I'm coming to that now. But Mr. Ngalwana, representing Dr. Hlophe, added the point that in fact there are far more. There is an issue the JSC ignored, which is that the High Court judgment impugns the designation, including of the 5 other members. And I took advantage of, because I was at that paragraph, just to highlight that point, that in fact that submission is inconsistent with the content of the judgment itself and how it hangs together in reasoning why there were sufficient prospects of success in the review of Dr. Hlophe's designation. It's because the failure to exercise a discretion ignored a relevant factor, which is that he was removed by the same body, which doesn't apply to the others.
Yes, but I think Mr. Ngalwana clarified that his submissions in that respect really went to the bounds of convenience. Not sure he was suggesting that the JSC was irrational because it had taken the wrong view of the full court's decision on that point.
I'm indebted to my Lord to clarify that, because then in respect of balance of convenience...
I essentially put to him, I didn't put it in these words, but first of all, you've got to look at the order.
Yes.
The order doesn't say anything about the other five. And secondly, if there are passages of this judgment that might be read in that way, they are passages that lead to an interlocutory order.
Yes.
Not final definitive findings of the fitness or the lawfulness of the appointment of the other five. And that's when I think Mr. Ngolwana said, well,
it goes to balance.
It goes to balance of convenience, really.
Yes.
It's not about rationality.
I appreciate that, my Lord, that clarification. The submission I would make is, when we get to balance of convenience, that doesn't get into the port.
Yes. Well, I mean, you may well have your submissions to make there.
Yes. Just going into the Constitution then, we start that, my Lord, at paragraph 52 of our heads.
Yeah.
And we start off by setting out section 178 and making a couple of submissions related to that. Paragraph 54 is simply to say that subsection 3 provides that members of the Commission, other than those designated by the NCOP, serve until they are replaced by those who designated or nominated them. Then we refer to decisions and how decisions are made. And 178, it's where certain designated members may not be able to attend, and there's provision for alternates. And under 57, we make the point that the clear import of section 178(1) of the Constitution is that once persons meeting the criteria of subsections A to K have been designated in the manner and by the person or entity prescribed, the JSC becomes properly constituted. So the Constitution and presence at a meeting are two different concepts.
Yeah.
We make the point. And then we refer to the 50-50 split, which is 178(1)H. And 59 is the effect of the Western Cape High Court order, which is simply only that he's prohibited from participating. He remains a member. And so the High Court order has not affected or altered the split, which is a composition issue, the 50-50 split. It's an issue of attendance, whether you will maintain the 50-50 split, and I come to the attendance issue.
Yeah.
And while the courts in 62, while the courts have acknowledged that the list of office bearers composing of the JSC is carefully structured, the cases confirm that the absence of a JSC member does not, without more, invalidate the proceedings or the JSC or its decisions. And that's where we tend to the relevant judgments, because they make it very clear that it is only when the absence lacks proper justification that there might be a nullification of JSC proceedings and decisions. But where there's proper justification, there isn't. And that's a ratio, that's the reason of principle, that all of the judgments that our learned friends referred to are discussed in the Hlophe case, which is a case involving the first applicant and the second applicant.
The full court decision in this division.
The full court decision in this decision, which is binding on this court. We summarize at 63 that Dr. Hlophe had relied on the Skirrod principle that if a statute prescribes specific office bearers to attend meetings and does not prescribe a quorum, it's assumed that all of them must attend, and that otherwise the proceedings where not all attend would be a nullity, and the decisions made would be a nullity. My Lord, the judgment of the full court dealt at length with the implications of all of the SCA judgments that our learned friends have said to my Lord they bind the court. And my Lord will see at paragraph 30, from paragraph 38 of that judgment, of the full court judgment. It follows on a discussion of the Skirrod principle and says at 38, the SCA, however, in JSC versus Cape Bar, considered itself bound by its judgment in Premier SCA, saying that it follows that if the JSC cannot take a valid decision in the absence of either the Premier or her alternate, the position can be no different with regard to the absence of both the President of this court and his deputy. However, like in Premier, the SCA held that it was because of the lack of justification for the absence of the President of the SCA and his deputy that the JSC was not properly constituted at its meeting, and that its decisions at that meeting were therefore invalid. What emerges then from this case is the inference that proceedings will not be regarded as a nullity if there are justifiable reasons for an absence or exclusion of a member entitled to sit. The justification qualification was crucial to the findings in respect of composition. Therefore, it would be a mischaracterization of those cases to say that they are analogous to the present matter or that they provide authority for the proposition advanced on behalf of Hlophe JP in the present case. It would be a mischaracterization of those cases to say that they dictate that generally, in the absence of the President and Deputy President of the SCA, the proceedings of and decisions taken by the JSC were invalid. Those cases tend on the absence of a justification for non-compliance with the composition requirements. They are therefore, as was submitted on behalf of the JSC, wholly distinguishable from the case with which we are seized. And why? Because in this case, we are furnished with reasonable and adequate justifications for the absences of Maya and Petsy DP. The justifications of Maya P and Petsy DP were uncontested. Both judges explained their absence on account of their personal relationships with Hlophe JP, so it's a conflict issue. On the basis of the above cases, then, their justified absence do not render the proceedings a nullity. There were valid reasons for their non-attendance. They were not unjustifiably excluded, nor were they unjustifiably absent. In the light of this, there was a reasonable justification of their replacement. My Lord can read further. And here, there is justification. The justification for his exclusion is the binding court order of the Western Cape. Our learned friends can quarrel with that judgment. What they have failed to do is to get its operation suspended so that it doesn't provide justification for his absence from JSC proceedings. The argument of our learned friend, Mr. Ngalwana, starting off under interim interdict with what is the right. He says he's got a right to participate in JSC proceedings. My learned friend, Mr. Hlophe, says that's a political right. He's got to represent, take part in the activities of MKP. Yes, true. But why can he not exercise those rights now? Because there is an interdict, which in terms of Section 1 of the Constitution, read with Section 2 and 165.5 of the Constitution, is binding on the JSC and on Dr. Hlophe. He can't go there and attend without being in a contempt of court. And that is the reason why he's not there. Our learned friend says somehow it is the JSC that is depriving him of the opportunity to participate, because if it postponed, well, they can't say if it postponed the proceedings, he would participate. All they can say is if he postpones the proceedings, there might be clarification whether he should or shouldn't participate, because one can't proceed on the assumption that he's going to succeed in his appeal against the interim court order of the Western Cape High Court, or indeed in Part B. They might find against him, so he might never return to the JSC, ultimately. So one can't approach the argument on the basis that if the JSC postpones, Dr. Hlophe is going to participate. No. If the JSC postpones, Dr. Hlophe will vindicate the case he has against the parties that went to court, whether he should be in the proceedings or not. And the only debate, the real debate, is should the court restrain the fulfillment of an important constitutional function to wait for Dr. Hlophe to vindicate his rights, which he has so many avenues to vindicate. He could have suspended the operation of the judgment. He can expedite the proceedings. And because the JSC proceedings are not invalid by reason of his absence, no constitutional provision is breached if the JSC in the meantime carries on and expedites proceedings to clarify his position. There is no reason to jeopardize the functioning of the courts, of the judiciary, and the proper administration of justice, just so that in the unlikely event that the court had him in Part B and in his appeal, he might succeed. He might succeed, my lord. He may not succeed. So with respect, all three reasons that the JSC offered are not only rational, they are correct, my lord. And there is no basis for this court to find that the JSC acted unconstitutionally as the declaratory relief seeks to the court to do. And I've addressed the fourth basis, which was dumped into the balance of convenience category, but that too doesn't assist. So when our learned friends say, but the court must look at the constitutional impacts of not having Dr. Hlophe on the JSC, that is an argument that they've made and they failed on before the Western Cape High Court, because the Western Cape High Court would have been met with an argument that Dr. Hlophe has political rights, he must carry out a constitutional duty on the JSC, you cannot interdict it. When you do that, you're upsetting the whole constitutional arrangement, including the 50-50 split. The High Court said the 5 will be there. That's sufficient. The majority will be there. That's sufficient. That finding and that judgment is binding on the JSC, is binding on the applicants, is binding on this court, because it hasn't been suspended. And it will only be set aside on appeal. And the courts have made it very clear that the fact that a judgment may be set aside on appeal doesn't mean in the meantime, unless suspended by a court under Section 18.3, is not binding, continues to bind. The right to continues to bind. So with respect, we submit that there is no case for the declarator. The real point why you have a declarator put up like that is that MKP is quite aware that it would face a difficult hurdle to clear the outer test for interim relief. That's why it wants the court, in a sense, to read into Section 172B of the Constitution and Section 38 to allow for a court to grant an interim interdict in the A without meeting the 4 requirements for interim interdict, which have been clarified by the Constitutional Court as being constitutionally compliant, and there's no need to fashion a new test. And when I come to interim relief, which is what I will tend to, it is that test which must be complied with, and we submit that is not met at all. My Lord, if I can tell...
Just on that point, if an organ of state takes a palpably irrational decision, must a court still consider some variant of the outer test or the outer test before it says so and grants appropriate relief? I mean, it just seems to me that the submission that you just made is either not correct or has its limits.
Yes.
It's one thing to say, well, if a party before court has a good chance of succeeding in an application for final relief, and the respondent is the state, and the state has special duties, one has to take account of the impact of restraining the state from fulfilling those duties pendente lite. And that is separation of powers harm. And it's usually located at the balance of convenience leg of the stage, of the test.
Yes.
But it is, I think, conceptually distinct, isn't it, to say, well, actually, what we want you to decide is not anything on an interim basis. What we want you to declare is that here and now, this decision was irrational, and because it's irrational, can have no force or effect. Those are two distinct arguments, aren't they?
Yes. So we would submit that if the court finds that the JSC decision is rational, there's no scope for interim interdict being granted.
Yeah.
Because you would never have, you can't demonstrate a right that's been breached. There's no right to a postponement. There's only a right to a rational decision, a proper consideration of your request for a postponement and a rational decision. So once the...
Well, if I were to decide that the JSC's decision was irrational.
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 Yes.
Irrational. Should emphasize our syllables, shouldn't we? Then it follows from that I must conclude that the decision was taken in breach of Section 1C of the Constitution.
Yes.
It follows from that I have a just and equitable power to determine an appropriate remedy under Section 172.
Accept that.
Yeah. That's a completely different railroad from Umkhonto we Sizwe or Dr. Hlophe's rights have been breached prima facie by the JSC's decision. They may or may not in due course get a declaration or have a court conclude that finally and definitively that those rights have been breached.
Yes.
And for that reason I apply the interim interdict test, which includes outer, because the JSC is an organ of state.
Yes.
Those are two manifestly different propositions, aren't they?
Yes, they are. The only point is when the court considers just an equitable remedy and following upon a declaration that the JSC decision was irrational, the factors that we raise under balance of convenience are still relevant in that they speak to the public interest.
Yes.
Because that just an equitable remedy, under just an equitable remedy, the case law is quite clear that public interest is paramount. So you would still consider whether it is a case in which just because a declaration of invalidity has been issued, there must be a consequence that the proceedings mustn't take place. They are either postponed or interdicted. So it's not an outer structure, but the facts that are referred to in the assessment of interim relief, especially in relation to balance of convenience and harm.
It's conceivable that a court could say, well, I don't think the JSC was rational in this particular instance.
Yes.
But here is a rational basis on which they should proceed.
Right.
Well, there's no reasonable basis on which they shouldn't proceed.
Yeah.
Therefore, it's just and equitable that they proceed.
Yeah.
That's conceivable. I'm not saying that's what the facts of this case say.
Yeah.
Not even saying that I would even get that far. But I could just leave it at a declaration, couldn't I?
Yes.
Depending on the facts.
Quite. It's conceivable that the court might say, of the three reasons the JSC gave, one or two are not rational, and in its view, they are the predominant reasons.
Yeah.
And therefore, they render, I think that's the approach that the SCA adopted in Westinghouse, where they said there was a dominant reason, is in a tender context. The reason you have applied is a reason that was not stipulated in the tender evaluation criteria. Therefore, that's an impermissible reason and is the predominant reason, and it renders the decision irrational. So if, on the other hand, assuming the court were to find that the JSC was correct, that the judgment is binding, the JSC was correct that the proceeding with the meeting on Monday is not unlawful because of what the full bench says, but there's some other reason for which it would have been in the interest of justice, or a factor that the JSC didn't consider should have been considered, and the court takes the view that renders the decision irrational and can warrant a declaration of irrationality, of invalidity. It doesn't follow that there must be a postponement and or an interdict. Yes, but I'm very indebted to the court for drawing, for splitting the routes, as it were, to the outcome. But one can wish away what has been pleaded. Yes.
Thank you.
I've got 5 minutes left.
Yeah. By my count, 2. But
my learned friend says I can borrow another 5.
It's absolutely fine.
Another 5 from them.
You're in a position to round off your submissions,
yes.
Are you? Then that's fine. Thank you.
On the requirements for interim relief, Malot will find our heads from paragraph 97. We've set out 4 reasons why he doesn't have a right, Dr. Hlophe. First, he doesn't have a right to attend the proceedings because of the interdict, which is in place. Secondly, there's no right to a postponement. He was entitled to a rational consideration. That's what he received. And the court has already found that there are sufficient prospects of success in the review of his designation, that would annul his right to participate, so to speak, because that's what the court found. Yeah. And the fourth is the appeal right doesn't require an interdict, my lord. There's a special remedy in section 18.3 and 18.2, yeah, if you want to protect that. And on balance of convenience, we've said much of what we need to say. It's all in the affidavits. It's really his interests versus the public interests here. And also, where the right is not strongly established, balance of convenience would have a much more pronounced consequence. And on irreparable harm, we've highlighted the case in City of Tshwane, which says that one of the crucial elements that must be established before an interim interdict can be granted. And that irreparable harm is the irreparable harm linked to the relief that you seek, and is your irreparable harm. In this case, he's talking about irreparable harm to the Constitution, to the JSC, to the public interest, but it must be harm that one can link to him and is irreparable. And we've submitted that is reparable, because if he succeeds in his appeal or in Part B, he comes back. In the meantime, the proceedings go on because they can do so lawfully under the full court judgment of this division. Alternative remedy, we've mentioned all the alternative remedies that he has. The Section 18.3 remedy for him to attend, because there's no point in postponing. The whole point here is about him attending and participating. Is the Part B and the appeal, which can be expedited. And at the end of our heads, from paragraph 109, we have a section dealing with dire consequences for postponing the JSC's October sitting, and that is all about the administration of justice, my lord. That is a factor that applies to the balance of convenience.
Yes.
My lord, we submit that on all of what we've submitted in the affidavit, in the heads, bearing in mind this is urgent court, this application should be dismissed. We don't seek a cost order. We simply ask the application be dismissed.
Thank you.
As the court pleases.
Mr. Bishop.
My lord, I'm not going to deal with the issues in the same way as my learned friend looking at the prayers. I intend to address them in the following order. First, I want to make a few remarks about the nature of the challenge that's before this court. Then I'm going to deal with the designation of the 5 other MPs, other than Dr. Hlophe. Then I'm going to deal with the presence of Dr. Hlophe at the JSC. And those are the 2 main grounds on which this relief is founded. Then I'm going to deal with Section 18 and 18.2, whether this is final interim, whether it matters or not. I'll then deal very briefly with the interim interdict requirements. I would have covered most of the ground by then, but I have a few remarks. And then finally, I have a few things to say about remedy and the relationship between Section 172, 1A and B. The first point is that prayer 2 of this application is a review. It's framed as a declarative, but what it really is a review of the postponement decision. Because if this court were minded to grant that declarative, that would trigger not only its power, but its obligation under Section 172, 1B to consider what other just and equitable relief to grant, which may include a reviewing and setting aside, or may include some other relief. But that's exactly what happens in a review, is the court decides whether the decision is lawful or unlawful, and then decides whether to set it aside or not, whether to suspend it, whether to grant other relief. It's a review, final in effect. That much has been said repeatedly. The first point is that prayer 2 of this application is a review. It's framed as a declarative, but what it really is a review of the postponement decision. Because if this court were minded to grant that declarative, that would trigger not only its power, but its obligation under Section 172, 1B to consider what other just and equitable relief to grant, which may include a reviewing and setting aside, or may include some other relief. But that's exactly what happens in a review, is the court decides whether the decision is lawful or unlawful, and then decides whether to set it aside or not, whether to suspend it, whether to grant other relief. It's a review, final in effect. That much has been said repeatedly. But what is it a review of? It's not a review of a final substantive decision by the JSC to appoint or not appoint certain judges. It's a review of a step in the process, a decision to have a meeting. So it's a review of a decision in medias res. And there's direct precedent for this issue, which is the case of the Public Protector of South Africa versus Chairperson Section 1941 Committee. The citation is 2023 ZAW-CHC 73. And that was a case in which the former Public Protector, Advocate Mkhwebane...
Give me that reference again.
Sorry, 2023 ZAW-CHC 73. That's the Safley reference, my lord.
2023 ZAWCHC
73.
73.
So it was a decision of a full bench of the Western Cape High Court. And what happened is Advocate Mkhwebane, during her Section 194 impeachment proceedings, brought an application challenging various decisions that had been made, to refuse postponements, to not recuse themselves, various decisions that the chairperson and another member of the committee had made, and including a decision not to grant a postponement at a certain point. And what the court said is that when you're challenging, this was in the context of Parliament, but we submit the same applies to the JSC, is that ordinarily courts will not entertain reviews of decisions in medias res. What you're required to do is wait for the final outcome, and then you can review that decision. And there's good reasons, because otherwise organs of state, like Parliament, like the JSC, are hamstrung, are unable to do their duty. So it's only where there's grave injustice or irremediable harm that cannot be remediated by review in due course that a court will even entertain reviews in medias res. But the other reason I mentioned this is it's important to think what the JSC had to decide here is, should it proceed with a hearing where it is going to interview candidates and make decisions or recommendations to the President about who should or should not be appointed. And what I had to decide is, well, is there a risk that if we go ahead with this hearing, that our decisions that we make will be compromised in some way and may be liable to be set aside? And I had to take whatever risk it thought might exist and weigh that against the cost of granting the postponement. And the cost has been set out in detail. And it's obvious. There's a cost to the administration of justice because judges will not be appointed. And there's fruitless and wasteful expenditure of 3 million rand at least. So those are the obvious costs. And that's what the JSC was doing. And so it's weighing that risk. And the question for this court is the way it weighed the risk irrational? Was it irrational for it to say, well, I don't think there's much risk that these decisions, any decisions we might take, might be set aside. The cost of postponement is massive, so I'm going to refuse the postponement. Was that rational? It was obviously rational. And I'll get to why the risk is, if there's any risk, is incredibly low in this case. And so what the JSC, the decision it took was, as Mr. Mayanesha said, not only rational but correct. So that brings me to the first sort of substantive basis, which is the position of these 5 other members of Parliament, the remaining delegation of designees. And before I get there, I think it's important just to clear up some lingo. The difference between composition, attendance, and quorum. And I think this is usefully set out in the JSC's heads. But we disagree slightly with what they say. That the composition is, have these people been designated, the people listed in 178.1. And there's no dispute that they've been designated. Everybody, including Dr. Hlophe. The next question is, who needs to attend of those people have been designated in order for the JSC to act lawfully? So I'll get to the case law later, but we submit that what the position is all the designated people must be invited, they must know about the meeting, and they must either be present or there must be a justified reason for their absence. And if those conditions are met, the JSC can go ahead and take lawful decisions. The word quorum is somewhat misleading in the case of the JSC, because nowhere does it set what we traditionally call a quorum, where it says X percentage of members must be present. What it says is a decision must be taken by a majority of members. So any decision must be a majority of the members, not members present, members of everybody of which the JSC is composed. So if 2, 3 members are absent because they're sick or a court interdicted them from attending or for whatever reason, they still need a majority of the members in order to take a decision, not a majority of members present. But that's not a quorum issue. That's a how many votes do you need to take a decision issue. And sometimes these issues get confused that they use it somewhat interchangeably, but if one looks at the full court judgment, it's very clear that what they're really concerned about is attendance. It's not composition, it's not quorum, which isn't really an issue at all, it's attendance. So, turning to the question of these 5 designees, we say there's 6 reasons why the JSC was correct to conclude, 1, there's no risk, but even if there is a risk, it's a minuscule risk. The first reason is that only Dr. Hlophe was before the High Court. The DA, Full Corruption Watch, only challenged Dr. Hlophe's decision. And Mr. Mayanesha took you to the paragraph where the Full Court expressly says it's not affecting the position of the other 5. It says they will attend. So that was clearly the position. The second reason is that their designations are valid until set aside. Oudekral, Kurland, basic public law principle. And in this case, not only have they not been set aside, they haven't even been challenged. It's a very peculiar feature of this case that the Part BB review is framed as a review of the postponement decision, not a review of the designation of the 5 members, which is then put up as the reason why the postponement was bad. Nobody has challenged it. MK, Dr. Hlophe haven't even said that they intend to challenge it. And there's probably a good reason for that, because their position in front of the full court was that the mistake of law rubber stamping review ground was bad. And so if they were to challenge it, they'd be advancing an argument directly contradictory to the one they used to defend Dr. Hlophe's designation in the challenges brought by the 3 applicants. The third reason is that whatever the full court might have said is not final. It's prima facie. It's very clear that its findings are prima facie findings. And we know that particularly because it refused expressly to grant final relief that was sought before it. Freedom under law didn't seek interim relief. It asked for final relief on these same grounds. The DA called it mistake of law, Full called it rubber stamping, but the same ground. And Mr. Trengove, who was then arguing for freedom under law, argued vociferously to the, well, maybe that's wrong, argued persuasively, cogently. Trenchantly, that's the correct word.
Yeah.
Trenchantly.
Trenchantly.
I wouldn't say cogently.
That is the kind of word I would associate with Mr. Trengove.
Trenchantly, that the court had no choice but to either grant or dismiss that relief.
Yeah.
And the full court took a different view. It took the view that it wasn't obliged to decide it and did not decide it. So we know it was only prima facie. Yes, some of the language is strong. We see that in interim interdict cases all the time.
Yeah.
Judges maybe express themselves trenchantly. But as a matter of law, what was decided is there is a prima facie right and nothing more. The fourth reason is that there is a substantive difference between Dr. Hlophe on the one hand and the 5 other designees on the other. And the important issue is when these nominations were made, the 6 nominations, there was no objection by any political party to those 5. The only objection was the objection raised by my client, the DA, and it was only raised with respect to Dr. Hlophe. And if you look at the debate, the Hansard, the debate was only about Dr. Hlophe. So, in substance, there was agreement. Not only was there which was the position for Dr. Hlophe, well, we may not like him, but there's nothing we can do about it. For the other 5 notes, no, we like them, we think they're great. Let's send them to the JSC. So whether the same ground of review that may or may not in due course succeed against Dr. Hlophe will succeed against the 5 others seems very doubtful. They're very different cases. And because no one's reviewed them, we don't know the record, we don't know much about them. I mean, there's a further point that even if a court found that there was some technical irregularity in the designation of those 5 people, what remedy is it going to grant in those circumstances? Is it going to set them aside with retrospective effect? Or is it going to say, look, I'm going to grant your review, suspend the order, and then go and fix it, because everybody was happy with these, but go apply your discretion you now know you have, and let's move on and avoid any disruption. It seems quite likely that's going to be the outcome. Which leads me to the 5th point, which, if there is a review, we've got to consider the remedy, and what is there a review of? So there might be a review of the designation, there might be a review of the decisions taken by the JSC, and the decisions of the President to appoint. But even at that point, we know from the Cape Bar decision, for example, that even if you say the proceedings of the JSC were unlawful, that doesn't mean that the appointments of the judges that followed was unlawful. Because in that case, there was a review of a decision with regard to the Western Cape High Court, at which certain judges were not appointed and Judge Henny was appointed. And the court said, yes, we're declaring this meeting invalid. Judge Henny's appointment remains valid because nobody's asked to set aside his appointment. And so what would have to happen for there to be any actual risk? Because the risk we're talking about here, if we're going to be honest about it, the risk is down the line, judges who are appointed might have their appointments set aside. And that risk is so minute, because even if you get to that point, you have to review not only the meeting, you have to review the appointment decision. And what court is going to actually set aside the appointment of a judge because of this kind of technicality? The risk is, I would say, close to zero. The sixth reason, my lord, is that this isn't raised in the letter that MK writes to the JSC. The issues that are raised in the letter are Dr. Hlophe needs to be able to participate, and if he's not there, the proceedings will be invalid. And then, as Mr. Mainecha pointed out, there's a vague indication that the 18-2 may or may not suspend the proceedings, we're not sure. Suspend the order, we're not sure. This point is not made in the letter. So it's not something that the JSC did or could have directly considered. And maybe there's a good reason it wasn't made, because it's not a very good point. My lord, I finished this section. I see it's 1 o'clock. I don't know if the court wishes to take a lunch adjournment.
Would you like to carry on until 1:15 and then have another quarter of an hour at 2 o'clock?
I'm in the court's hands. I'm happy to
get back a tiny bit of time.
Yes.
We carry on until 1:15.
I might finish by 20 past. Let's see how it goes.
Let's see where we are at 1:15.
So the second issue is the participation of Justice Hlophe. So the argument here by the applicants is that if Justice Hlophe is not on the JSC on Monday, then the JSC will be acting unlawfully, and anything it does will be unlawful. And so you should postpone until he can participate. It's very interesting, as Mr. Mainecha again pointed out, that the relief sought is not Justice Hlophe must participate. The relief sought is don't do anything because he can't participate. But the argument is obviously bad for two reasons. The first is that the Western Cape Full Court has held that it can proceed. The point of the urgent proceedings, and this was abundantly clear in the papers, was abundantly clear to everybody who was in front of the Western Cape High Court, was that the applicants wanted the proceedings to go ahead next week, but we wanted them to go ahead without Justice Hlophe. That was the context in which the decision was taken. At paragraph 45 of the judgment, what the full court says is, during the intended sitting of the JSC, interviews for the position of Judge President of the Western Cape Division will take place, in addition to vacancies for the Supreme Court of Appeal and other divisions. Any participation of Dr. Hlophe in these interviews, it was argued, will undermine the integrity of the JSC and the public perception of its ability to perform its constitutional function. So our concern was, we want these to go ahead, but if Dr. Hlophe is there will be the real risk. And that's what the court ultimately upheld. And then in paragraph 68, the court said, in granting the same, the JSC will function in his absence, but if required, the NA may always designate another MP nominated by the opposition party to take his place. Irreparable harm befalls neither Dr. Hlophe nor the MK. So it says expressly that the JSC will function in his absence. Mr. Mainecha also took this court to paragraph 56. I'm not going to take you back there, but paragraph 56 of the full court judgment really makes the same point and shows that it considered the composition issue. It refers to the Premier of the Western Cape judgment. And it said, yes, despite that, there's no difficulty with composition. And the only argument I heard my learned friend, Mr. Mpofu, make in response to that is, well, the court said quorum, not composition. But that's an error of linguistics, not an error of substance. It was absolutely plain to the court what the issue was, because it was argued by, I believe, Mr. Masuku and Mr. Katz before the High Court, this precise issue, that Mr. Hlophe had to be there, otherwise there would be a composition problem. And we know it's a composition problem because the court refers to Premier for Western Cape, which is a composition case. Oh, sorry, I'm getting my wording wrong. It's an attendance case, not a composition case. We're beyond composition. It's an attendance case. So it's not open to this court to reconsider what the full court found. It's binding on all the parties here. And that should be enough. It so happens the full court was correct. And we know it was correct because of what the full court of this division said in the Hlophe case. Paragraph 39, Mr. Mainecha read it, I'm not going to repeat it. But it's crystal clear that when there are justifiable reasons for the absence, the JSC can continue, even if some of the members of which it is composed are not present. And so what Mr. Mpofu argued in response to say, yes, but you must look at the SEA cases, Cape Bar and Premier Western Cape, and you mustn't look at the full court decision in Hlophe. That's wrong for two reasons. Firstly, because what the full court does is interpret the two SEA decisions. It refers to them in detail, and this court, as a single judge, is bound by their interpretation of the SEA judgments. It's not permitted with respect to go behind that interpretation and say, you were wrong in how you interpreted the judgments. But in any event, those cases say exactly what the full court says they say. There was a claim made that one of the members of my client, Ms. Helen Ziller, was flip-flopping because she was at the stage the Premier of the Western Cape, and she was making complaints about composition, and now she has no complaints. But it's important to go back and look at what happened there. What happened there is the issue the JC was considering was the removal of Dr. Hlophe, then Hlophe JP. And Ms. Ziller, the Premier of the Western Cape, was not even informed about the sitting. So paragraph 4A, she was not present because the JSC had not notified her when and where the meetings were to take place. And she was unable to comply with her obligation to attend as required by section 178(1)K. So it's in that context in which the decision is taken, where you refuse to invite somebody. And the whole debate there was only about whether a Premier is required only for appointments of judges to that division or also for removals. That was what the case was about. It's interesting, at paragraph 21 of the judgment, the SCA says there was another potential difficulty about another absence. It says the Court of Quo also found that the JSC, again on its own version, was not properly constituted, and that one of the practicing advocates to be appointed in terms of section 178(1)E had not been appointed by the President. The point adds little to the previous one, and I prefer to leave it open, especially in view of the fact that it is not known why the advocate had not been appointed. So it's clear then that there's also an issue of, well, what is the reason why this person is or is not there? And then if we look at the Cape Bar case, the relevant paragraph is paragraph 36, where the SA says, I therefore agree with the Court of Quo's finding that in the absence of the President of this Court and his deputy without justification, the JSC was not properly constituted. So not only is this court, like the full court in the Western Cape High Court, was, well, I'm not sure it was bound, but it followed the decision here in Hlophe, but they were correct in their interpretation of the two SCA judgments. So those are the two main pillars in this case, and they both fall completely flat. There's no merit to them whatsoever. And they created no meaningful risk for the JSC that would have justified it saying, because there's some remote possibility that sometimes somebody might bring a review of something that may or may not be unlawful, that may or may not lead to a remedy that impugns the decisions we take, we're going to waste 3 million rand and leave our courts unstaffed for months and months on end. And that's the rational thing to do, because that's the applicant's case. That brings me to section 18. And the first point is that this really, whether the decision of whether the applications for leave to appeal suspended the operation of the full court's order doesn't matter. And it doesn't matter because the result of suspension would be that Dr. Hlophe would be entitled to attend. And that's never been the demand, and that's never the relief. That wasn't the demand made to the JSC, and that's not the relief they seek now. And so it's really an irrelevancy, whether it's been suspended or not. So if they were correct that the judgment has been suspended because of the applications for leave to appeal, what it would mean is that Dr. Hlophe is entitled to appear on Monday and say, I'm entitled to sit here. Not that the JSC shouldn't hold any interviews. But the second issue is, even if it does matter for some reason, we submit obvious that the decision falls under section 18.2, that it is an interlocutory decision that does not have the effect of a final judgment. And I think it's important to distinguish here between questions of appealability and the question of the application of section 18.2. Our law on the appealability of interim interdicts is, I think, somewhat contested at the moment. And whether the test might be different in the Constitutional Court versus the Supreme Court of Appeal versus appeals from the Magistrates Court. When can you appeal even if it's not final effect, if it's in the interest of justice? There's, as I read the law, some confusion on the issue.
Yes.
But
I mean, Zwini's a good guide to finality, isn't it?
Zwini is a good guide to finality, and that's the question
and
here.
The problem that you're setting out is that finality and appealability have been separated from each other.
Yes.
We just don't know how separated and in what circumstances.
But what we do for section 18.2, because section 18.2 is a statute that tells us.
Yeah.
And so that the test is there.
Yeah.
Does not have the effect of a final judgment.
For the purposes of interim effect, yeah.
For the purposes of interim effect. We don't have to worry about...
But Zwini's still a good guide to whether an order's final or not.
Yes.
Yeah.
But the interim interdicts have always been regarded as interlocutory orders that don't have a final effect. And that's so for very, very good policy reasons. Because otherwise there would be a waste of time. Because I would go to court and get an interim interdict, normally sought in urgent proceedings, to preserve a position or alter a position for a period of normally months until final relief and an action or review, whatever it might be. And if that could be undermined by simply lodging an application for leave to appeal, and then losing it, petitioning the SCA, losing it, petitioning the Constitutional Court, and that process inevitably takes up to a year, it would be an automatic right, effectively, of any litigant to suspend the operation of any interim interdict simply by pursuing their rights to appeal. And that's why Section 18.2 says what it says. Interim interdicts would be rendered nugatory if they were not, if they were suspended by the lodging of an appeal. There will be the rare case where an interim interdict is final in effect, because by the time you get to the review will be moot, or by the time you get to the action. Cronshaw is an example. This case is an example. If this court granted the interim interdict in this case, and we treated Part BB as a review, by the time we get there, the review is moot, because the postponement has happened as by dint of the interim interdict. It would be of academic interest only, the review. So if this court was minded to grant the interim interdict, there would likely be an appeal, and it would be final in effect, and it would suspend the operation of the order. But that's an unusual case, because of what is being sought to be reviewed is the postponement which will be achieved fully and finally by the interim interdict. But the decision of the full court is not like that. The decision of the full court leaves Dr. Hlophe as a designee to the JSC. He's still a member of the JSC, and it lasts only until all it says is you may not participate until the review is determined. It's always the case that interim relief has a final effect during the interim period. That by definition, that's what it's meant to do. That doesn't make it final. If we say that is final effect, every interim interdict is final in effect, and that's never been our law.
Well, the question is whether it meets the three tests of
Yes.
finality. Disposes of a substantial part of the relief claim, is definitive of rights, not just that some things can't happen that would happen without the interdict.
Exactly.
Yeah.
And ultimately the rights that are at issue is, was the National Assembly's decision to designate Dr. Hlophe lawful or not? And that is an open question that has not been determined between the parties, and will only be determined when the court determines Part B. That's the substance of the dispute. The Part A dispute was, well, what should happen until that substantive dispute is decided? Should he come or should he go? Should he be on the JSC or not? And that's classic interim relief. So we submit for those reasons that the Section 18.2 point doesn't get the applicants anywhere. My Lord, I'm almost finished. If I might have another few minutes, I think I can wrap up in the next 3 or 4 minutes.
Yeah.
That brings me to the requirements for interim relief. So just to take a step back, the primary relief sought is what is really the review of the postponement. It's called a declarative, but it's a review. It's quite strange, and it's final relief. It's quite strange to say, I want final relief. In the alternative, I want interim relief. Because if you lose on the final relief, how can you ever get the interim relief? Because the court would have made a decision that there is no right.
Well, I mean, that's why I had the exchange with Mr. Hlophe I did.
Yes.
There are two different bases. The first is the rationality of the
Yes.
postponement. If it's irrational, that's a final declarator. In relation to the interim relief, it's the constitutional rights, mostly the Section 19 rights that the applicants say they have in these circumstances.
Yes, so I think as I read it, there's two bases sought for the interim relief. The one is the prospects of success in the review that's going to be in Part B, but if the court refuses the declarator, there cannot be no review. The other is the various rights that are asserted on behalf of Dr. Hlophe, on behalf of the National Assembly, on behalf of the JSC. Mr. Meinet is quite right that Dr. Hlophe and the MK Party can only assert their own rights. But with regard to that category of rights, that's been determined by the full court of the Western Cape. Because all these same arguments were made to that court. There was in the context of balance of convenience, Dr. Hlophe argued, you shouldn't preclude me from attending the sittings of the JSC because it will affect all these constitutional rights I have.
Yeah.
And the full court said, yes, we'll consider that, but we're going to preclude you from attending. And granting an interim interdict on that basis in this court would be to effectively set aside the decision of the full court. Because nothing new has happened other than the postponement decision, which is knocked out one way or another by Prayer 2. And once that's either that they get that relief, they don't get to interim relief, or it's knocked out and therefore it's irrelevant to these other prima facie rights that are asserted. And that's the same case that was before the full court, just the other way around. That we were seeking to prevent him from attending and he's seeking to force his attendance. But the decision is the same. And the same goes for irreparable harm. That's also been determined by the full court. It says no irreparable harm will be suffered by Dr. Hlophe or the MK Party. It says so in terms. On the question of alternative remedy, we've set them out. They can pursue their appeal, they can seek Section 18 relief in the Western Cape High Court, they can review the appointment of the designees, the 5 designees. And we also, we make the point, and we're going to stick to it, that they could have asked the National Assembly to designate a different member of the MK Party to sit this week. This point was raised again in the full court in front of the Western Cape. The DA expressly said in its founding papers that if the relief is granted, the MK Party will be entitled to go and ask the National Assembly, say, we want you to withdraw Dr. Hlophe's designation and designate a new person. And the National Assembly never said it couldn't do that. It was expressly put, it didn't say, no, we can't do that. It didn't say, no, we can't on a functus basis. It didn't say, no, we can't on a timing basis. And we see no reason why they would be functus, because what you're doing is you're sending a designee. You can always say, well, I want to send a different designee. A party may say, well, yes, this person's B on the JSC, we'd rather now have somebody else, please designate person B. And that option hasn't even been exercised. The MK Party hasn't approached the Speaker and said, please, can we urgently this week try and send a new person, a new Member of Parliament, so that we have representation on the JSC. They've sat on their hands and brought this application instead. Lord, I was going to say something about remedy, but I think I've covered it in what I've said previously. On the issue of costs, we seek our costs. We seek the costs of 2 counsel. This may be constitutional litigation, but the applicant and the DA are private parties, not organs of state. BioWatch has no role here. It may with regard to the JSC, but not with regard to my client. We also seek punitive costs, because we submit that this is an abusive application. It should have been immediately apparent that the full court has dealt with this matter, and that the decision not to postpone was not a decision that could reasonably be said to be irrational in these circumstances, for all the reasons I've given. It's difficult to understand, given the way the case is structured, the way it was brought, why it really was brought, because the applicants never seem to actually ask for the relief they want, which is for Dr. Hlophe to be on the JSC. So we submit it was an abusive application entitled to cost and attorney-client scale C, counsel.
Well, if you want attorney-client costs, you can't have costs on scale C.
Oh, then you'll say, well,
scale C applies to party and party.
Yes, so if
somebody
we
raised
do party and party. I believe so.
Yeah.
But those are my submissions.
Thank you. It's just after 1:45. I am going to suggest that we adjourn until 2, and then we hear from Mr. Duplessis. Thank you. Court adjourns.